Rahman Shakira binti Johari and my metric number is 277701. Today I would like to talk about the case study which is North Sea Continental Shelf 1969. International law nowadays is commonly made by treaty between nations. It also can be arise from the established custom of nations in dealing with one another. The distinction matter treaties only by the country that signed the treaty. Customary international law by every country. West Germany, Denmark, and Netherlands all had North Sea coastline. They had agreed on the coastal sea border but not on the border of continental shelf, which has oil and gas. Denmark and Netherlands had signed the Geneva Continental Shelf Convention. This treaty talked about the deciding dispute continental shelf boundary, but Germany did not sign the treaty. The convention applied a principle called equidistance, it basically means drawing a line equally distant to the coastal boundary of each country. Due to the shape of West Germany, equidistance would have give the West German a small proportion of the North Sea compared to the two countries which is Netherlands and Denmark. Before the International Court of Justice, Denmark and Netherlands argued that Geneva Continental Shelf Convention had been applied so broadly that it was now customary international law binding on the West Germany. But the court considered how the treaty can become customary international law. The court said there is no doubt that this process is perfectly possible one. At the same time, the result is not likely to be regarded as having been attained. In this case, they consider several factors. First, whether the treaty create an equidistant rules at all. This was doubtful because first, this treaty required countries to negotiate first and only apply equidistant if they could not. This treaty also allowed divergence from equidistant in special circumstances. So, this treaty, there was no clear rules. Second, the court considered that for a treaty provision to become a customary law, there would have to be broad acceptance of the rule even by the country that outside of the treaties. In the North Sea Continental Shelf in 1969, there was no evidence of that in this case. Finally, even if equidistance had become the common method, there would have to be evidence that the state were applying that method from the sense of a legal obligation. The court was said the state concerned must therefore feel that they are conforming to what amount of a legal obligation. The frequency or even habitual character of the act is not in itself enough. In a conclusion, as a result, the treaty did not apply in this case, and there is no customary international law. So, Germany, Denmark, and Netherlands had to return to the negotiation and sort out among themselves.
30 years ago, on December 1988, over 270 people were killed when a passenger plane, Pan Am Flight 103, exploded over the Scottish town of Lockerbie. The evidence pieced together from the fragments on the crash site led to the conviction of Bassett al-Megrahi from Libya. But 30 years on, a full picture of what happened and who exactly is responsible still remain unclear. Hi, my name is Lydia, and on this part, we will uncover the unsettled case of the Lockerbie disaster. The Pan Am Flight 103 was a regularly scheduled transatlantic flight from Frankfurt, Germany to Detroit via London and New York. On the 21st of December, after taking off from the first stopover in London, a bomb exploded from the inside of the cargo bay while the aircraft was mid-flight. The explosion created a hole on the side of the plane, which led to the depressurization, and eventually it crashed onto a residency area in Lockerbie, Scotland. All 270 passengers of the flight, with additional 11 people on ground, lost their lives. After the incident, an investigation started by the US-Scottish Joint Investigation Team, which led to the identification of two possible suspects from the Libyan intelligence agency, which is Abdul Basit al-Muhammad Ali Megrahi and Al-Amin Khalifa Fhimah. The US Scottish government made the declaration for the Libyan government to hand over the suspects to be charged with the crime. However, the Libyan authority at the time had refused to do so. Libya insisted on the rule of Article 7 of the Montreal Convention 1971 as the governing principle, which is entitled it to prosecute its own nationals. Even so, the UN Security Council had imposed economical and political sanctions on Libya until the accused were handed over for trial. Following that, a number of Libyan assets abroad was frozen, except for oil exports revenue. Even when faced with the sanctions, Libya feared that the two suspects would not get fair trial on Scotland because it seemed that the United States and the UK are certain to their issue of guilt. However, Libya agreed to hand over the two suspects for trial in December 1998, and on April 1999 the two suspects were finally handed over to the UN and the sanctions have since ceased. On the 31st of January 2001, Al-Amin Khalifa Fhimah was acquitted of the murder charges and Abdul Basit al-Megrahi was charged as guilty unanimously by the judges. Megrahi was sentenced to life imprisonment with high recommendations to serve at least 20 years before being eligible for parole. It seems that Libya was right to be concerned that their nationals may not be given a fair trial. After the court decision, an appeal has been made again, and on the second hearing in October 2007, it was revealed that a number of CIA documents that were shown to the prosecution were not disclosed to the defense. A key witness also stated that he misinterpreted some facts and some evidence were politically engineered. Regardless of the court decisions and rulings, can it be possibly that the case of Lockerbie bombing politics has been put before justice? So that is it for our video. I hope that our explanation has provided great input to the viewers.